So, when all of the witnesses have concluded giving their evidence, and when the tribunal judge feels that they have all of the information they need to conclude their own judgment, they will normally indicate that the witnesses have provided enough information, and that the process will then move to what's known as closing submissions. So both you as the respondent and the claimant will be given an opportunity by the judge to probably take a short break, possibly half an hour or so, sometimes even overnight if it's a longer hearing, to collect your thoughts and to sum up the key strong parts of your own claim or your own response, and the areas that you see as the weaknesses in the other side's position, and to summarise those in a closing statement to the judge. The judge may then ask some final questions, or they may then say, well, they have enough information to make their judgment, and they will then adjourn the hearing. Again, that adjournment may be fairly short. It may be just half an hour or so, or it may be that the tribunal feels that they need more time to consider their decision. In a relatively straightforward case where the judge feels like they have enough information to make a decision there and then, they will then call you back in, and it may be that you get your judgment, so the outcome of the hearing, whether or not the claim is successful or not, there and then, which is usually the ideal scenario because you get closure at the hearing itself. But it may be that they decide that they simply don't have, or they need to reflect on the information that they have and the evidence that's been put to them for a longer period. So it may be that they will say, we will send you a written judgment in due course, but that would never normally be more than 4 weeks or so after the end of the hearing. So ideally, and in most cases, you'll get the judgment there and then. Sometimes you may need to wait. So once the tribunal judge has made their decision and given you the judgment, the final thing to decide, if any parts of the claim have been successful, the final thing to decide is remedy. Remedy means what is it that the claimant actually receives by way of compensation for the claim that they have successfully brought. Usually remedy is just a financial thing, so it's simply the tribunal will decide what the loss that the claimant has suffered is and order that the respondent makes a payment of compensation to cover that loss of earnings. But it may also include things such as re-engagement or reinstatement, if that's something that the claimant has asked that the tribunal consider. So re-engagement or reinstatement would mean that the tribunal may have the power to tell you as the employer to reinstate the individual into their previous role, or to re-engage them into a different role within the same organisation. That's pretty rare. Most of the time it's just about financial compensation for loss of earnings. You'll recall that at the CMD stage I told you that the tribunal will have laid down a timetable. As part of that timetable, it may be that they have also it may be that they will have also asked you to consider providing evidence relevant to remedy. That wouldn't normally be overly complicated, but it will probably mean that you will need to give some thought to what you say the claimant earned in their role, what you think they could have or should have done to find alternative employment after they left their employment, if it's a dismissal-related claim. So once the tribunal has given judgment on liability, so whether the case is successful or not, they deal with remedy. And they will deal with that at the same time at the end of the hearing if they possibly can, but if they can't, again, they'll defer that possibly to a later date, and they'll tell you when that is likely to occur.